Good morning, everyone. I hope that you can hear me for this live event today. So I think we're live now, so I'll start again. Good morning, everyone. I hope you can hear me, and welcome for joining today. This is an event organised by the East of England Local Safeguarding Adults Boards in conjunction with the Opg, and I'm very pleased that Essex Safeguarding Adults Board is hosting this particular event today. So my name is Giles Goodeve, and I'm pleased to welcome all of you to this event. I'm welcoming you on behalf of the Essex Safeguarding Adults Board, and as some of you will be aware, Paul Bedwell was the previous Safeguarding Adults Board's manager, and he very recently left ECC to take up a new role. So I'm presenting on his behalf. So he was involved in the Eastern Region events and the setting up of these, and I'm aware that there's been a number of these kind of events, and they're kind of planned on a yearly basis. And these webinar events are very much obviously kind of learning for organisations. I'm very pleased that we've got Amy McElroy here from the Office of Public Guardian today to be able to support us with this event. So as you'll be aware, the objectives of these sessions are really to explore the topic for the day, and to think about that in relation to the emerging issues from the pandemic, where we're at this particular point of time. And then also to identify any relevant lessons and learning that we've got for us as organisations, either looking back or also looking forward. So I'm very pleased to introduce Amy now from the Office of Public Guardians. She's going to lead this presentation. I'm aware that she's going to say something around the kind of learning objectives and thinking through what the session is going to provide you with today. Obviously, she'd be more than happy to take questions from you. There's the question and answer function that you have the option to be able to post questions in. But please note that she'll be happy to kind of take those questions at the end, and she'll answer those. But please feel free to put any of those questions in the chat, and we will monitor that as we go through. So I'm going to hand over to Amy now. Amy, over to you. Thank you very much.
Thank you, Giles. Good morning, everyone. My name's Amy McElroy. I'm the Operational Delivery Manager for Supervision and Investigation Services with the Opg. I'm based in Birmingham, and I've been with Opg for 12 years now. The session today is separated into 4 separate modules. So the first one is a bit around Opg itself and lasting powers of attorney. The second is around safeguarding team. The third is around the investigations team. And lastly, there's a short bit around deputyships. As Giles mentioned, I will be happy to take questions at the end. I won't be able to see them until I've finished the presentation, but I'm more than happy to go through them at the end. I do have a colleague with me as well. Jenny Gorder is here, who is a senior investigator with the Office of the Public Guardian. So she'll be helping me go through the slides and possibly answer any questions at the end. So with that, we'll make a start. So the Opg is responsible for maintaining the register of lasting powers of attorney, LPAs, enduring powers of attorney, EPAs, and deputyships. We are regulated by the Mental Capacity Act 2005. We also are regulated by the Code of Practice, and we also have the Public Guardian regulations, which really tell us how we can do our roles within the Opg itself. We do only have jurisdiction in England and Wales, so this is important when we are considering investigations around assets. So if a person has assets outside in England and Wales, we don't have jurisdiction to consider those. But if a person is living outside of England and Wales but still has assets within, then we can consider those concerns. We provide guidance to professional deputies who are appointed by the Court of Protection. And as you can probably tell from my role, we investigate concerns around attorneys and deputies. The main difference between those two is that an attorney is a person that's appointed under an LPA or EPA, whilst a deputy is appointed by a court order issued by the Court of Protection. Okay, Jen. So this map that you can see now just shows the correlation between where you're most likely to find a diagnosis of dementia compared to where you will actually find the most LPAs. Our teams have been doing a lot of research into this to see why people aren't taking LPAs. Are there areas that they could actually prove to be a valuable asset to those people? We have parts of society that don't have LPAs but could really benefit from having one. And we've been doing a lot of research around what is stopping people from taking out an LPA. So the next slide just gives a few figures around that we're actually considering as part of the research at the moment. So one of the main beliefs is that an LPA is only useful if a person's lost capacity, whereas it can obviously be useful before that. So we have people that are in the armed forces that have LPAs that may wish somebody to look after their financial affairs if they're deployed abroad. There's also other situations, whereas people that may be involved in an accident could benefit from having somebody manage their affairs whilst they are recovering. And we're obviously aware that with the ageing population, the number of elderly is going to increase, and therefore it can obviously help those people to manage their affairs as well as any care arrangements that may need to help. The point that we are currently looking at is that an LPA is useful for those that are in good health as well as those that do already have a diagnosis. So as part of the research, Opg interviewed quite a lot of people, and there was quite a few myths that came out of the research around people's understanding of an LPA. So the first one was that in hospital, the next of kin always gets the final say in treatment, which is false. The health professionals get the ability to make that decision unless there is a health and welfare LPA in place. So that one, 72% of people thought that that was true. And for a financial one, if a couple have a joint bank account and their home is in joint names, 73% of people believed that they would be able to make a decision for the other party. That's also incorrect. If there is an LPA, then yes, they can act on that person's behalf. And with a joint bank account, there is the guidance that they do actually have jurisdiction to touch those funds, etc. But with a property, ideally they do need to apply for the court of protection if they want to sell that person's share of the property, unless of course there is an LPA in place. So things that we would like everybody to know, this is not just yourselves, this is everybody that we would like to know things. We do encourage people to register their application as soon as possible. What we mean by this is that when you complete, or when a person completes an LPA, they often don't send it in for registration. This is because they don't want it used until they are losing or may have lost capacity. But the concern that the OPG have with this is that there can often be errors within the application that would invalidate the LPA. If at that point it is invalid, if a person no longer has capacity to either amend the errors or create a new instrument, then unfortunately they would then have to go to the Court of Protection for a deputyship order. With the LPA property and affairs, the donor, who is the person that is giving the power, can actually indicate whether they wish the LPA to be used straight away, so as soon as it's registered, or if they don't wish it to be used until they are losing or have lost capacity to make those financial decisions themselves. So they can actually choose to have the power used later on, but have it registered in the meantime. With the health and welfare LPA, it can't be used at all until somebody has lost or is losing capacity to make those decisions. So that's why we do urge people to register their application as soon as possible, just in case there are any errors that could be rectified in the meantime without them having to then make a deputyship application later on. So the Court of Protection, as mentioned, they will issue deputyship orders, and those deputies are supervised by the OPG. They do incur costs, which I'll go into a bit more later on, but the LPA is the more cost-effective alternative to that. For an attorney, a donor can choose whoever they want. It could be their family members, it could be their next door neighbour, and many people do choose to have a solicitor or a financial advisor if they have complex affairs, but they don't need to. It can be anybody that they choose. Whereas a deputy is appointed by the court, so it may not actually be that person's preference who is appointed by the court. The LPAs also allow for instructions and preferences, so this can be anything from I do not wish my attorneys to have the ability to sell my property, or it could be the complete opposite, that my attorneys can sell my property but they cannot use my finances on a daily basis. So it is up to the donor which powers they are choosing to give. And with the health and welfare, they also have the ability to put instructions and preferences around that. So that could be something like I wish to remain in my own home for as long as possible, or that I wish to go in a specific care home. That can also be considered by attorneys. So as Giles mentioned earlier, we are looking around things that have happened during the pandemic. During this, OPG have done a lot of work around digital services. We've introduced new digital services of make an LPA, use an LPA and view an LPA, which I will go into in a little bit more detail. But just to finish off this slide, it can take around 12 weeks to have an LPA registered. This is due to the notification period, which gives people the opportunity to object to an application. So we have to allow 4 weeks for that objection period. Next one, Jen, thank you. So one of the new services that has been introduced by the OPG is to check an LPA online. This was introduced to limit attorneys or donors having to carry around the physical document. So this service can be used to check if an LPA or EPA is registered, who the attorneys are. For this, you do need an access code. So at the moment, when an LPA is registered, the attorneys and the donor are provided with an access code. They can share this code and it enables them to see the LPA online and check that it is still registered. And it also enables them to share this with other parties. So this could be yourselves or care homes or banks. So the next slide just gives a screenshot of what you'd actually see if you used this service. So as you can see from that, it is through the gov.uk website. You'd use the donor's name and the access code that would be provided to you. And on the right hand side is the information that you'd see. So the name of the attorneys, how they are appointed to act, and it would also indicate on here whether that is a valid instrument. So it would be updated if the LPA is revoked by the donor, or if the Court of Protection asks the OPG to revoke it for any reason. We've also introduced the rapid register search. So some of you may know that you can actually do a search of the OPG register. This is usually a 5-day service, which is done Monday to Friday. With the pandemic, OPG became aware of concerns around hospital admissions and that the NHS and local authorities may require a search result more quickly than that in order to see if there is an attorney appointed or a deputy, or whether the health professionals need to make a decision around somebody's care. So we introduced the rapid register search, which is a 24-hour turnaround. This is still only Monday to Friday, as we are not open over the weekend. But if we do receive something over the weekend, it is dealt with as a priority on a Monday morning. This was initially set up purely for NHS staff, but it has been extended out to local authorities and the police, and it is something that OPG are going to keep in place now. So we do urge anybody that needs an urgent request to use the rapid register search. If it is not an urgent request, then we ask that people continue to use the standard search of the register, which is done through the gov.uk website with an OPG 100 form. So the information that you would receive if you asked for a rapid register search is the same as you would from a usual search. So you'd be told the type of instrument that the OPG holds, the appointment type. So this could be whether the attorneys are appointed jointly, so they can only make decisions together, jointly and severally, which means they can make decisions separately, or jointly for some and jointly and severally for others. With the last one, the donor would indicate what decisions they wish to be made jointly. So the most common one is that attorneys must act jointly regarding the sale of my property, but can act severally for all other decisions. So you'd receive that information as well. For health and welfare, you'd be advised if the donor is giving the attorneys the power to make decisions around life-sustaining treatment. You'd also be told if there are any restrictions in the LPA and if it has actually been revoked, or if it's a deputyship order, whether this is expired, or if the court has revoked that deputyship order, sorry, or if there is an expiry date in place. So the next slide that you can see now is a template. It is available on the gov.uk website. This just gives an idea of the information that we would require when you are contacting us. You can copy it from the website if you wish to, but the main thing is to make sure that we know it's urgent and give us as much information as possible so that we can get that information back to you as soon as possible. The different types of LPAs, I've gone through them briefly already, but there are the two. For an EPA, there is only the one type. It can only be used for finance and property. There is no health and welfare EPA. LPAs, there are finance and property and health and welfare, and they can both be used for daily decisions, which can be anything from ordering prescriptions for health and welfare and utility bills for the finance and property, right up to your bigger life decisions around selling a property, dealing with any assets and investments, or moving into a care home. People do still use professionals, so they may ask for assistance from a solicitor or a financial advisor. This is allowed as an attorney. The only thing that they can't do is delegate their responsibility. So they couldn't give a bank card to that solicitor and say, you deal with all the finances, but they can obviously get legal advice or financial advice where needed. So OPG and the impact of the pandemic. As mentioned, we've tried to improve our digital services to help other parties that may need it, from local authorities to care homes. We've adapted new ways of working. So as you may be able to tell, we're currently working from home to allow our colleagues that need to be in the office the space to be there. And we've also extended our campaign into the Bame backgrounds. So this is with the research around whether they may be more susceptible to the pandemic, and whether LPAs could be of assistance there or through deputyship orders through the Court of Protection. So this next module looks at our safeguarding team. So the safeguarding team, or as we call them, the ITAS team, which is Investigations, Triage and Safeguarding. They are the first point of call at OPG for concerns that are raised. They are responsible for what we call risk assessments. So when we receive a concern, they will be the first people to view that, and they will be looking at it to see, do we have jurisdiction for this concern? Do we have the correct instrument? If we don't, they will be making referrals to the correct professional authorities, which could be yourselves or the police or other parties like the Solicitors Regulation Authority. So their initial aim is, as I said, a risk assessment. Their first point of contact is local authorities. So they'll be reaching out to see, is this person known to you? Are there any safeguarding inquiries open? And do you have an indication of a person's capacity? The reason we do this from the very beginning is because OPG do not have jurisdiction to investigate where a person has capacity to deal with those concerns themselves. So rather than cause any upset through an investigation where somebody may have the capacity to deal with it and do not wish the OPG to be involved, we do try to gain an indication of that person's capacity as soon as possible. We will also contact the concern raiser to get a bit more information around the concerns themselves and see if they are able to assist with any capacity evidence or any other evidence that may help with a possible investigation. If we do not have jurisdiction, the team will try and provide some guidance or signpost to other bodies that may be able to help the concern raiser. And if it is determined that we do hold the correct instrument, and what I mean by that is if the concerns are of a financial nature, do we have a financial LPA in place? If we don't, then we would not have jurisdiction, so we would try and provide either advice or we would make a referral ourselves if necessary. So the safeguarding team themselves are looking at concerns around finances, care. So these can extend from small things. So it can be gifting, any concerns around gifting, failure to pay care fees or personal allowance, financial abuse, which can consist of either using somebody's funds for their own gain or neglecting to pay for things that they actually require. So this can even be utility bills if they're failing to pay a donor's utility bills, or if they're withholding funds from them when it may be a person that does have capacity for day-to-day affairs, but maybe not have capacity for larger decisions, and they do still want to be involved in their day-to-day financial decisions. Charges made by professionals. What we mean by this is those people that do appoint a solicitor or a financial advisor to act on their behalf are often aware that they will have to pay fees for that privilege. And many do have an indication of what those charges will be within their LPA. We do find on some occasions that these charges are exceeded, and we can obviously investigate that to see were these exceeded for a reasonable reason. Has this person done enough work? Have they done what they're claiming for? So we can investigate those and if need be, refer it to the Solicitors Regulation Authority. This does include deputies and attorneys. So my colleagues in Nottingham have responsibility for investigating deputies, whereas my colleagues in Birmingham have responsibility for investigating attorneys. If the safeguarding team do decides that it is an investigation, it will be passed over to the investigations team. This is usually done within 5 days of receipt of the concern. The chart that you can now see shows you the number of concerns that OPG received. Just to give a bit more context to this, OPG now has around 5 million LPAs on the register. So from the bar graph, you can see that it is actually a small amount of concerns that we receive, and an even smaller amount that are sent over for an investigation. The reason for this is because a lot of the concerns that we receive, we do not have jurisdiction to investigate. The main one being anything that is prior to registration. So if somebody has committed financial abuse before the LPA was registered, unfortunately, OPG do not have jurisdiction to investigate. And whilst we may not have jurisdiction ourselves, we can obviously make referrals to the police if need be. Currently, 0.15% for concerns raised, 0.06 of those are sent over to investigation. That's around 30-something%, I believe. For the financial year of 2020 to 2021, OPG received around 5,000 concerns. So it does sound like a lot, but in context to having 5 million LPAs, it is actually quite a small amount. So the way in which an LPA can help, as I mentioned earlier, it may not be those that have a diagnosis. It can be anybody that needs it for either a short period that they may revoke later on, such as those in the armed forces, to those that do have a diagnosis and are more vulnerable to possible scams. So things like the text messages that come through purportedly from your bank, to emails that you're due a refund from HMRC, and things that an attorney may pick up on by looking at somebody's statement. So this could be if a person doesn't usually spend cash, but all of a sudden there's a lot of cash withdrawals. An attorney can then take steps to see what is happening on that account. Is it the donor, or is it more of a concern that they need to take action on? Things like setting up regular grocery shopping, they can do that on behalf of the donor. So they can do bits of online shopping for them, have it delivered to their home, have a regular shopping order set up if need be, and for things like prescriptions to be delivered. So it can extend from safeguarding those that are maybe vulnerable to anything from telephone scams, right through to just helping them with daily things like their shopping and prescriptions. So the safeguarding team do work with a number of parties, as mentioned, where they can make a referral at any point. And that is the same as the investigations team. They do not wait until the end. They will make that referral if need be. And they will contact bodies such as yourselves, the police, GPs, and care homes to get the information required to ascertain whether we do actually have jurisdiction to investigate or not. So what we would recommend is that you do use the search the register. If it is urgent, you can use the rapid register search, refer concerns to us. You can do this through the gov.uk website as well, or you can either send an email to the Opg Safeguarding Unit. The email is at the end of the presentation if you do want it. But the main things are checking if you are advised there is an LPA, checking it's still valid. There may be instances where it has been revoked in the meantime, so I would suggest checking that whenever you feel that you need to, and if you do have concerns, to contact us and send them over. So if a concern is valid and it is sent over to the investigations team, it will be allocated to an individual investigator. That person will be responsible for the investigation until the end. unless there are circumstances which it may need to be reallocated, but otherwise the majority will remain with the same person to provide consistency for contact throughout. The investigator will do a review of what has been received by the safeguarding team, so they'll just double check that we do have the correct instrument, if any further evidence has been received, and whether we have jurisdiction in terms of are the concerns pre-registration or can we look at them. It may be that there are a number of concerns and we can investigate some but not all. So that's what the investigator will be looking at, and they will narrow it down to where we have jurisdiction and what they need to do to gain some evidence around those concerns. We can also investigate fraudulent LPAs. So if it is believed that an LPA was created fraudulently, we can investigate that as well. The investigator, their first steps will be to create an action plan. So this is technically a living document. It does start off as set questions for various parties, and these parties can include anybody from the attorney themselves, which we can ask specific questions, through to GPs, police, care homes, banks. So anybody that the investigator thinks may be able to provide an insight around the concerns that we've received. When they've risk assessed this and they've made their action plan, this is reviewed by a senior investigator who can add in any additional questions that they think may benefit, or it may just be that they agree with the investigator's action plan, and at that point it is approved and the investigator can go ahead and start contacting those parties. One of the things that the action plan will indicate is what type of visit they are going to commission. So what I mean by this is the Opg uses two types of court of protection visitors. We have general visitors who are responsible for conducting capacity assessments. They will give an indication of whether a person has capacity at the current time to create or revoke an LPA, whether that person understands the concerns that Opg has received, and whether they have the capacity to make decisions around finances or health and welfare themselves. It may be a very specific decision, or it may be a general, as do they have capacity to deal with their daily finances rather than any larger decisions. So the special visitors are the other option available to an investigator, and these are qualified psychiatrists, that kind of position. They have a lot of experience and they are used where the investigator may need an indication of retrospective capacity. So these can only be done where there is a body of evidence for that special visitor to review, and they can only give a decision that is based on the balance of probability. So it's not a definitive decision of whether, for instance, did the person have capacity to make a gift of £5,000 3 years ago? If there's no capacity evidence available at all, then the MCA states that we must assume capacity. If there is a large body of evidence that a special visitor can review, they can then give an indication of whether it is likely that that person did have capacity or didn't have capacity to make that decision. Cases involving retrospective capacity decisions are usually referred to the Court of Protection afterwards for them to give a direction on whether they agree with the special visitor or not. We tend to use special visitors where there is no diagnosis as well, to ask them not to give us a diagnosis, but to give us an indication of a possible diagnosis if somebody hasn't actually received one. So once the action plan has been approved, the investigator will make contact and commission that visit. Then they are looking at the evidence received. So this can be a huge amount of evidence. Sometimes it's very little evidence. It depends on the concerns received and also the responses that are received as well. As you can probably imagine, financial can be mounds of evidence that are received, so it can take a while. We do try and complete investigations within 12 to 14 weeks. Sometimes this isn't possible. This can be due to delays in responses, or it can be due to the amount of evidence that has been received, but we do try and meet the objective. So the investigator will be looking at the evidence received. Any capacity evidence is referred to the visitor, so they have more evidence to look at, and they will conduct a financial analysis if needed. So this involves reviewing the bank statements, highlighting any concerning transactions. They will ask attorneys to account for specific transactions. If an attorney provides an account but we still have concerns after that, we can go back to them again and ask for clarification. And the investigator will do this until they have a clear picture in their mind around what has actually happened and whether these concerns are upheld or not. The final part of an investigation is what we call a PG report, which is a public guardian report. This report includes what the concerns are. It includes all the capacity evidence that is relevant to the concern and a review of all of the evidence that's been received. So it will discuss the finances if needed, or the health and welfare decisions that have been made, along with input from various bodies. So this can be the care home and the GP. All of that will be included within the report. The investigator will conclude their report with a recommendation. They currently have 3 recommendations available. So the first is no further action. This is where we don't believe that there has been a breach of the Mental Capacity Act or the Code of Practice. It could be cases where we find that the attorney just needs a little bit of advice. This could be where they are using a lot of cash, but they have got all the receipts. So it may be that we advise them to start using direct debits, things like that, just to make the account a bit more transparent. So it's not cases where they've done something wrong. It's just that they need a little bit of advice in order to provide a more transparent account. The second is further action. So this can be cases where there is a breach, but it is not extensive enough to have them removed as an attorney. So in cases like this, we will ask attorneys to complete a number of actions within a set period of time. This could be repayments of funds. It could be to arrange a payment schedule with a party if required. And it can also be in situations where we are asking them to apply to court for either gifting or the sale of a property, those kinds of decisions that they should have done, which they may not necessarily have acted maliciously in any way, and it may actually be a decision that's been made in the donor's best interests. But for the OPG, we do actually sometimes require them to apply to court just so they do have that permission and it is granted by the Court of Protection. If they don't comply with those recommendations, the OPG can then consider a court application, which is the third and final recommendation. A court recommendation can be made without further action, so it could be that there is enough evidence that this is a serious breach of their duties, or it could be that we need the court to give us directions on the validity of an instrument. So as mentioned earlier, this could be cases where we've received a retrospective capacity decision from a special visitor. We will then refer this to the Court of Protection to ask for their guidance on whether either the instrument is registered or if we need to remove it from our register. We can also apply for revocation, and we can apply for the court to order the attorney to account to OPG. So this happens in investigations where the attorney does not respond to us at all. So if we have concerns based on other evidence that we have received, then we can ask the court to order the attorney to account. If the attorney does not account, then we will ask the court to revoke them at that point. So those are the 3 recommendations available to the investigator. These recommendations are then reviewed by their senior investigator, who may make some small amendments. They may add in an additional recommendation, such as a specific action in further action. And it's then the report is then sent to a public guardian signatory. So these are a small group of people that the public guardian has delegated his responsibility to approve or reject the recommendations of an investigator. Some of these, including ones where we are recommending a court application, are also reviewed by our legal team, check whether we do have enough evidence or if the actions of the attorney do warrant a court application. So we will involve them as early as possible to avoid any delays later on if we don't have the correct evidence and we may need to seek more. So once the investigator's report has been approved, they can then start to implement those actions. So this can be notifying parties that we are not taking any further action and the case will be closed, or advising attorneys that they do need to take some very specific actions and come back to us and we will provide a date. Or we'll be informing parties that we may be making an application to court, at which point some parties may be sent a COP4. If we are recommending that somebody becomes a deputy, we will try and include a COP4 from the application to court as early as possible to avoid any delays in having a deputy appointed. As I mentioned earlier, the safeguarding team do work with a number of parties, so do the investigators. The investigators will be contacting police, local authorities, care homes, GPs. They will contact anybody that they think can provide some evidence. Next one, please, Jen. They can also make referrals at any point during their investigation. So we could refer a matter to the police on day 1 of an investigation. We don't always wait until the end. If there is already a police investigation and we are aware of that, we will contact the police at the beginning to check if they are happy with us to proceed, as we obviously don't wish to step on any toes or cause any disruption to a police investigation. So if we are aware of one, we will do that at the very beginning just to check that they are happy with us to proceed on that basis. And the local authorities, we will ask them, is there any safeguarding inquiries that we need to be aware of? Is there any evidence that can assist in us building an indication of capacity, or any alternative evidence that you may hold that could assist within the investigation? So the last module, this one is fairly short. So the deputyships team, as I mentioned earlier, is slightly different in that deputies are appointed by the Court of Protection rather than by a donor, but their investigations are quite similar. So a deputy who is appointed by the Court of Protection can be appointed as Property and Affairs or Health and Welfare, or both. A deputy can only be appointed if a person lacks capacity to make those decisions, so it does require a capacity assessment, and deputies are supervised by the Opg, whereas attorneys are not. So for deputies, there is a supervision fee. This is taken from the client's estate. So under a deputyship, the person is known as a client, whereas under an attorneyship, it is a donor. So the security bond is also required for deputyships, which is not required for attorneys. There used to be a number of supervision levels. This has now been reduced to 2 supervision levels just to make it a bit more transparent and provide more assistance to those deputies who may require it. So they're on the two supervision levels are now minimal and general. The minimal is clients that have assets under £21,000 or professional deputies. So those that don't require much assistance from Opg, they've been doing it for a long time and they don't need much support. Whereas the general are usually clients over £21,000 in assets or new deputies. So somebody that is new to the role needs a bit more support from the Opg so they understand what their objectives are and what is required from them by the Opg. Regulation 41 of the Public Guardian Regulations that gives the Opg the authority to investigate. The deputyship investigations are done, as mentioned, by my colleagues in Nottingham, and they can be investigated for the similar reasons as an attorney. So mismanagement of funds or failure to act, or ways in which they could be acting beyond the court order. So it could be that they've been appointed by the court with very direct responsibilities and they have either exceeded those responsibilities or not met them. So we can investigate those depending on what the concern is and what type of deputyship order has been put in place. There are 3 different types of deputyship investigations. Next one, please, Jen. So first is deputy compliance cases. These are fairly straightforward cases. These are ones where the court order has been issued and the deputy has failed to comply with that. This could be something like they have failed to report to the Opg. Deputies have to provide an annual report. If they have failed to do that, then this can be referred straight back to the court as a breach of the order. Or it could be that they haven't paid their bond. So they are usually pretty straightforward and can be referred straight back to the Court of Protection. The second one is supportive type 1 deputyship cases. These are usually cases where a deputy is acting in very difficult circumstances and they may need quite a bit of support from the Opg. The most common one is where there has been a previous deputy and this person has been revoked by the court. A new deputy is then appointed to investigate the actions of the previous deputy. So they will need a bit more support in getting to grips with the person's finances and the decisions that were previously made by that person. So they'll need contact with somebody in the deputyship team to help them get to grips with that and figure out what has actually happened so they can report that to the Opg and, if necessary, the Court of Protection if the court have asked for a report. And the last one is Regulation 40 cases. So Regulation 40 is, again, one of the Public Guardian regulations. Jen, next one, please. And this is for former deputies. So this is a little bit different from attorneys in that if an LPA ends, this could be due to revocation, the death of the donor or the disclaimer of an attorney, then Opg lose all jurisdiction to investigate. But a deputyship can be investigated after it's ended, and this is with a final report. So the Public Guardian has the authority to call for a final report from a deputy. This could be in a situation where the client has passed away and the Public Guardian requests a final report on their estate and decisions made up until the point that they passed away. Or it could be that the deputy themselves has passed away and the Public Guardian will be asking for a representative to provide a final report on that matter. So this is just, I don't know if you want to make a note of any of these email addresses or contact details. You do have the safeguarding inbox there, as well as my own email address, and the head of supervision, Jill, her email address is on there as well. Most of the information that I have given today you can find on the gov.uk website, but if you do need any further information, feel free to drop me an email and I'll be happy to answer. And that is it. Thank you, everyone.
That's great. Thanks very much, Amy. That was a really helpful kind of presentation, covered an awful lot. It was really great that you kind of separated that out into the into different modules. It was really helpful, I'm sure, and a good reminder for people, or certainly for people who are coming to this fairly new, a really good overview of the Office of Public Guardians. So we've got a number of questions in the chat. So are you happy if I just kind of I'll work through those and kind of ask those as they've come up? Is that all right?
Yeah, of course, that's brilliant.
Great. Okay, so the first one I think that we had was about what age do you need to be to do an LPA? Can someone in their 40s make one?
They can indeed. You need to be 18. So as long as you have reached your 18th birthday, then yes, you can make an LPA. And your attorneys must have reached the age of 18 as well.
Yeah, that's great. Thank you. I'm just talking between the different questions. So the next one that we have got is, oh, actually, there's just a question more generally, Amy, actually about the slides as well. Are they able to be shared?
I can try and send a copy over, as I was having issues earlier with sending it as an attachment. But what I may be able to do is set up a SharePoint and send it to yourself, Giles, and maybe you can download it your side and share it. I will try. I'll try again. Absolutely
fine. That's great. Just obviously had a number of people who are interested in receiving the slides, obviously because that's helpful for them. And there isn't any issue, Amy, is there, in sharing those more widely within their own organisations?
No, of course not. Happy for those to be shared.
Excellent. That's great. Thank you. The next question is, can more than one person be listed on the LPA? I think you've answered that already, but just to clarify. Yep,
you can have as many attorneys as you wish. The other option is that you can have primary attorneys and replacement attorneys. So this is a situation that is most commonly used where somebody may appoint their spouse to act and then their children as replacements. So if anything happens to their spouse, their children can then act on their behalf, or they may choose to appoint all at once and have 4 or 5 attorneys that can all act independently. So, yeah, there's no limit.
Excellent. That's great. Thank you. So a question someone has posted, has there been a change as families tend to give or share a copy with us? I'm presuming that's either of the deputyship or of the LPA.
The only change has been the ability to share a digital version. So a lot of people were having to produce the physical instrument, which if you've seen an LPA, depending on how old it is, it can be up to 32 pages long. So this just enables them to be able to just show digitally that it is still registered, it is valid, what the appointment type is, without having to produce the physical instrument.
That's great. Thank you. A question now about the rapid register search. So someone has kind of posted, they noticed that it said these requests must come from an accredited email address. Can organisations get this accreditation prior to making these type of requests, or is it a set list that can't be altered, such as NHS, police, etc.?
What we mean by accredited is as long as it's your work address. So if you are local authority, NHS, your email will come through fine. What we're trying to avoid is encrypted emails. So some of you may use egress yourselves. What happens with egress is the way we work with the allocations, it'll be allocated to a risk assessor, but because it comes into a shared inbox, they then have issues with having to go back to request permission to view the email, so it can cause a bit of delay, especially in the rapid register searches. So as long as it comes from your work email, it should come through fine.
That's great, thank you. Right, just slight technical with the questions. Hang on. Okay. So can you state in the LPA with the two attorneys that in the case of disagreement that one attorney has the final say?
If they're appointed jointly and severally, which means that they both have the same power, none of them have the final say. If they cannot agree, we would initially ask them to make a decision between themselves, as the donor has appointed them both. If they cannot agree after that, then we do tend to recommend that they apply to the Court of Protection for the court to make a decision. If they don't, if it eventually becomes to a point where it is affecting the donor, then we can make an application to court ourselves to remove either one or both, or ask the court to make a decision on that person's behalf.
That's great, and I guess that could roll into other things, Amy, couldn't it, in relation to concerns from one attorney about another's kind of behaviour potentially, and that could also roll into other things rather than just can someone have the final decision if there's a disagreement. That could also be a disagreement that relates to concerns about how that attorney is behaving in relation to the donor, and therefore that could potentially result in an OPG investigation in its own right, couldn't it?
Yeah, we do actually see a lot where it is one attorney raising concerns about another. Sometimes it can just be miscommunication and it can easily be resolved. Other times that attorney is breaching their duties. So it is good that attorneys do raise concerns against each other, but sometimes it does happen that it can just be miscommunication.
Yeah, absolutely. Right. Let's find the next one. So have existing LPA holders been sent codes to the online record, and how do they get them if they've been lost?
They not everybody has. What has happened at the moment is the LPAs that are currently available digitally are from September 2019, I believe, onwards, but they are working backwards. So the digital team are currently getting more and more online. And those people can call OPG and request a code, and that will be sent out to them. We do understand that not everybody wants a code, so it's not a case of we will just issue out a code to everybody. It will be, if they do choose to have one, then they can contact us. But for the newer LPAs that are currently being registered, they will be sent a code once it's registered.
Yeah, great, thank you. Hopefully that clears that up. So next question is, do we need to obtain consent for an OPG 100 search?
No, you don't. The OPG 100 is just a general search of the register. It's open to everybody. So anybody, any member of the public, somebody's family, anybody can just do a search of the register if they think that there might be an LPA there, or as professionals, if you just want to check if there is one before you either make any safeguarding inquiries or raise concerns. Yeah,
and just to clarify that, Amy, for people, because obviously there'll be people on here who have a personal capacity as an LPA, but also obviously in terms of this call from a professional capacity. In terms of the actual OPG 100 search, just to clarify about how people would do that, the mechanism for doing that, and where they can find that search.
Yep, so the OPG 100 is available on the gov.uk website. You just complete that form and it gives you all the directions of who to send it to.
Yeah, great, thank you. What cost do deputies typically charge for holding a deputyship on behalf of a client?
It can vary greatly. So we have local authority deputies, and we also have family members. So a family member generally won't charge. There are some that have their charges input into the court order. So it can vary greatly. Obviously, if they're professionals, they will agree that charge with the Court of Protection before the order is issued.
That's great, thank you. It's slightly going back to a question that we had before, actually, Amy, which was just about the disagreements between two attorneys. But will disagreements lead to delays in providing services to the donor, was the question.
It can sometimes, if the disagreement is affecting the donor, then we will try and take more rapid action rather than just asking them to work it out themselves. It depends on if it's impacting the donor. We see a lot where they are disagreeing, but there's no impact at all on the donor. They're not aware that there's a disagreement and it's not having any detrimental effect. So each concern is taken on a case-by-case basis as to what the situation is and if it's impacting the donor currently.
Yeah. Okay. I think, Amy, that is. Oh, there's one more question. Are there any interim actions? I'm not sure what that relates to. I don't know whether there's not any more detail on that. If you have kind of posted in the Q&A, if the person who's done that can just give a little bit more information, that would be helpful to enable Amy to be able to answer that. I think, apart from that one question that will hopefully get some clarification about Amy, I think that is all the questions that we have. Is there anything else that you wanted to kind of say either about, or there are a couple of things I was going to mention actually, was just about, and I think you've answered it on your final slide, which is about kind of contact. Are there any specific, obviously there's contact details there for you, Amy, which is really helpful. So any other kind of contact routes which organisations should be aware of in terms of those? They can obviously kind of come to you with some kind of queries, and that's fine. I guess you could be having your kind of name or OPG kind of contacts out there more generally. Are the details on that slide, because it came up and then went before I was able to go through it, around the kind of general queries that organisations can raise their concerns with in terms of the OPG?
Yep, the Opg Safeguarding Details are on the gov.uk website. There is also the details for our contact centre on there. If you're unsure whether it is a concern or not, you can contact them. They do have a phone number as well. So all those details are available on the gov.uk website. Okay.
That's great. So someone's come back and said it related to the previous question. So if there are any interim actions relating to the previous question, I think that may well have been about the kind of the attorneys themselves, and if there were kind of disagreements, interim actions that might take place. I think you've kind of detailed some of those already, haven't you, Amy?
Yeah, so if we think that there are some interim actions that can be taken, we can ask them during the course of the investigation to take those actions if we believe that it may assist. Others, we can't make any interim actions until we've concluded the investigation because we don't have all of the evidence at the moment.
Yeah, that's great, thank you. A couple more questions have just come in. So can you request that a deputyship be moved from a court of protection appointed solicitor over to a local authority deputyship?
An application to court can be made for that. The deputyship team in Nottingham are responsible for matters relating to deputyships, so it can be done. The only thing would be that the court is unlikely to remove a deputy unless there's a reason why. It could be a simple reason, like the client doesn't have the funds for the costs of a professional deputy, or it could be that that deputy has misappropriated in a way. So yes, it can be changed if need be.
That's great, thank you. And then I think one final question. It's now just taking a bit of time. What actions have been taken to reach BAME communities?
To be honest, I don't know the specific actions, as I'm not part of that team. It's being dealt with by our customer relationship team. But I know that they were trying to gather more evidence around whether LPAs could be of assistance within those communities. I can try and find out and send it over with the slides if that would assist. But yeah, it's not my team. Apologies.
No, that's absolutely fine. Thanks, Amy. It's a really good question. and certainly if we can kind of have a bit of feedback around that,
Yeah.
that would be helpful. And even if you're able to kind of find out some of that, or we can actually put out some contact details, perhaps, as you say, for your customer care kind of service, and they're able to be able to give a little bit more information for that specific question and that organisation, because that might be something that's quite specific. I think that you've answered all of the questions that are there, certainly the ones that I can see, because they move around from screen to screen. So I think that is all the questions that we have, Amy. So Linda, I don't know whether you want to just go back to making me live. Alternatively, I can just speak from where we are. There we go. Okay, that's great. So I'd just like to say specific thanks to Amy and to Jenny for coming today to support with this webinar. It's been really interesting. It's certainly raised a lot of kind of questions for us and thought-provoking for us as organisations. Definitely got us to think about what it's been like during the pandemic and how some of those things have changed. Got us to thought very widely about the role of the OPG and as organisations, how we interact with it and the support that's available for organisations as well. It's been really useful to have some very practical examples, Amy, around the LPA and deputyship and how that works on a very day-to-day basis, because those are the things in the questions that very often come up from a kind of practice perspective, or from a perspective around concerns where we may think that there may be an issue. And certainly, obviously, from the perspective that we're all thinking about in terms of safeguarding adults, and what that process is that we go through, where we've got concerns and how we can link with the OPG around that. There's certainly an awful lot in that area, which is something that's constantly changing, Amy, isn't it? And there's lots of kind of, I guess, case examples around that are helpful for us to be able to use, and you've used some of those. I guess just one kind of final thing for me would be thinking about how organisations can engage with the OPG going forward, whether that's some kind of further sessions. Obviously, this is a session that's open to the Eastern region from a safeguarding adults perspective, but really useful if there's any information. I'm not expecting you to kind of give that now, Amy, about how organisations can engage perhaps directly with the OPG for their wider workforce as well. That would be really helpful to be able to support, promote the work of OPG and a greater understanding, but also organisations as well, and how we can support safeguarding individual adults from the perspectives that we're all working in. So if you've got anything that you would want to kind of share about that now, Amy, that would be helpful. Or perhaps if you want to kind of send something round when you send the slides to me, and we can get those kind of circulated, happy to distribute it in that way as well.
I can actually give you a little bit now. We have actually been delivering presentations to a number of local authorities over the last year or so. So we have tried to get in contact with each region. We've done over 50 presentations now, I believe, to local authorities. And I'm now in the process of actually recording them. So each module will be recorded so they can actually share them themselves rather than having a set time that everybody has to turn up to. So it is a work in progress. We'd obviously be more than happy to receive any feedback that you may wish should be included or could have been included. So more than happy for anybody to send over any feedback or ideas for future sessions. Happy for that as well.
Brilliant, that's great. And I think that probably relates to a final question, or the second to last question that I've just seen, which is in there, which is, are these sessions going to be held again? Obviously, I think you've answered that, Amy, which is OPG would be happy to have requests from individual organisations to be able to support with these seminars. So that's absolutely fine. But you've also said that you're going to be recording those, and I think that would be a really good resource. There is just one final specific question as well. So I think we'll make that the last one if we don't have anything else. So if a person who is assessed as lacking capacity on finance and property and or welfare and health previously, and so a deputy was appointed, but later is assessed as having regained capacity in these areas, can they revoke the deputy and be given as a donor for an LPA?
Technically, yes. So they would have to contact the Court of Protection with regards to their current capacity status, but
Yeah.
the court can revoke the deputyship order then, and then they can execute their own LPA, appointing somebody that they would choose. It may be that they choose their deputy to be their attorney instead. So yeah.
Yeah, brilliant. Okay, that's great. I think whilst I appreciate that, Amy, you won't necessarily be able to kind of see the chat as you're kind of toggling through. Lots of people saying thanks very much for today. Really useful, very informative session, and just thanking you for your time and obviously kind of expertise as well. So I'd just like to echo that, Amy and Jenny, for supporting us today. It's been a really good session. I don't think there are any other questions, so I'm not going to kind of hold people. We had the session booked till 11:30, so 13 minutes back of time to go and enjoy perhaps a bit of a sunny Friday for whatever you're doing. So wish everyone well. Really glad that you could attend today. Have a good rest of the day and a weekend. Thank you very much. Bye bye.
Thank you, Giles. Bye, everyone.